to the Mars rule. How many of you have heard of the Mars rule? Okay. Very confusing, and unfortunately, I don't have a real good answer for you as to this regulation at this point right now, but let me go through what it is. It's the Mortgage Assistance Relief Services Rule. It was issued by the FTC, which is the Federal Trade Commission. The rule went into effect on January 31st of 2011, so January 31st of this year. It prohibits certain practices and requires consumer disclosures in short sales. So we're talking about short sale transactions. And the reason this came about and was issued by the FTC is because of unfair and deceptive practices by foreclosure rescue companies. I'm sure all of you have heard some horror stories about foreclosure rescue companies where they charge upfront fees and did nothing, or they charged an upfront fee and did very little, and told maybe a seller not to, don't contact your lender, don't talk to them at all, and stop your payments and this kind of stuff. So there were definitely problems out there, and companies, it needed to be regulated. Unfortunately, the regulation that was issued is so broad that it can affect realtors involved in short sale transactions. NAR did request an exemption for realtors, real estate licensees. Unfortunately, it was not granted. And when I go through this, you'll see that it definitely is written for those foreclosure rescue companies, not for realtors, but because it's so broadly worded, it applies to you if you're involved in short sale transactions, unfortunately. So NAR is still in discussions with the FTC to try to get some clarification of how this would apply to realtors involved in short sales. But let me explain why it could apply to you. Mortgage relief services, because that's who it applies to, providers of mortgage relief services. That's defined as someone who is involved in negotiating, obtaining, or arranging a short sale. Well, negotiating is defined as broadly as communicating with a lender about the possibility of a short sale, or presenting an offer to the lender in a short sale, where the consumer's in a short sale situation, providing comps to that lender to support maybe an offer in a short sale transaction. So it definitely could apply to real estate licensees who handle short sales. I mean, you definitely, as part of the normal services, if you're doing short sales, very often we'll talk to the lender about the short sale and what they would accept, and help the consumer maybe get the information to the lender to find out what would be acceptable to the lender and what would not. Giving an offer to the lender to consider in that short sale situation. So talking to the lender about it. It does affect licensees who work in the short sale area. So arranging too, because it says negotiating or arranging. Arranging, let's say you don't personally talk to the lenders. You take listings maybe, but you know another person or an entity who's very good at those discussions with the lender. And so you will refer then that seller to that entity that you know is good at that. That is then considering arranging for mortgage relief services. And so that again requires you to comply with this rule, because you are arranging for short sale or for negotiating that mortgage relief services provider services. So that's why it potentially, and does, I'll have to say, it does apply to real estate licensees in short sale situations. Now, what are the prohibitions under this rule? If you are providing mortgage assistance relief services, you cannot collect an advance fee for services at all. So if you are a brokerage company, like I said, that was part of the problem in the past. Those foreclosure rescue companies would charge an upfront fee and do nothing. So they prohibit upfront fees. You can only be paid at the closing, okay, if you're providing those services, mortgage assistance relief services. So if you are a brokerage company that charges, and some do, an upfront fee, if you are providing for that consumer mortgage assistance relief services, so you're going to be talking to that lender about the short sale, you cannot charge an upfront fee. That's prohibited by this rule. No fee if the owner's loan is not modified. So again, there has to be a closing for you to receive a fee, or a mortgage assistance relief service provider. There would have to be a closing. No upfront fees are allowed There would have to be a closing in order to collect a fee. You cannot assist a MARS provider if you know they are violating the MARS rule. This gets into the situation where you're not providing those services, however you're referring them to a company that does. You need to make sure that that company that you're referring them to is meeting this rule, or you could be found in violation. So that requirement also. And it prohibits certain representations, and some of those are, you cannot tell the owner that they cannot contact the lender. It's a violation for stating that you are affiliated with or approved by a government entity, a nonprofit housing agency, or a program that that lender has. You cannot misrepresent the likelihood of obtaining well, any kind of result, but a favorable result for the consumer, and they cannot misrepresent that the consumer will receive legal representation. So those are some of the representations specifically that are prohibited by the rule. Now, what are the disclosures that are required? You have those prohibitions, and then you have certain disclosures that have to be made at certain times. There are 3 disclosures, so 3 different times where a disclosure has to be made. First of all, if you are advertising your services as a MARS provider, so if you are advertising for sellers who are in a short sale situation, or if you are advertising yourself as a short sale specialist, in that advertising, where you're doing that advertising for short sale services, you do have to have certain language, and I'll go over what that language, but in the ad, mandatory language is required to be in that ad. Also, there's a disclosure required. It's called the consumer specific disclosure. That would be at the time you're taking a listing, and the seller's in a short sale situation, and you are going to be talking to the lender, providing MARS services. There's a disclosure that has to be made at that time. And then the third disclosure has to be made at presentation of the short sale package. That's when the lender is approving the sale. They're accepting an offer, they're approving the sale, another disclosure has to be made. So those are the 3 disclosures. Now the first one, if you're advertising, and again, if you're advertising yourself as a short sale specialist, or if you're advertising for sellers in a short sale situation, there's certain disclosure that has to be made, and it doesn't matter the means that you're advertising. It could be print, radio, TV, websites, it doesn't matter. Here is the disclosure that has to be made. Important notice, and you would put your brokerage company name. It's not associated with the government, and our service is not approved by the government or your lender. Even if you accept this offer and use our service, your lender may not agree to charge or change your loan. If you stop paying your mortgage, you could lose your home and damage your credit. That's the disclosure that has to be made in the advertising. Okay? So if you are advertising yourself as a short sale specialist, or advertising for sellers in a short sale situation, you need to have that in your advertising. That is required. It's required now. That went into effect in January. So you definitely have to make that disclosure. Now the consumer specific disclosure, this is a disclosure that has to be made when you're actually going to take a listing for a consumer in a short sale situation. Also, if you take the listing and maybe they're not in a short sale when you take the listing, but it comes evident that they are now in a short sale situation, then this disclosure has to be made. Now, we didn't put the exact disclosure in here, but this is basically what it's providing. It's in your handout material, though. You may stop doing business with our company at any time. You may accept or reject any offer from the lender. If you reject, you do not have to pay us. If you accept the offer from the lender, you must pay, and then it has a line where you would put your fee in there. The brokerage is not associated with or approved by any government or by the government or a lender. The lender may not agree to any changes in your loan, and if you stop paying your mortgage, you could lose your home and damage your credit rating. So that's the disclosure that would have to be made basically when you're entering into the listing agreement. That's called the consumer specific. Now, what are the concerns with this? Well, many. Like I said, this disclosure really wasn't meant for realtors to use. I mean, it really doesn't make a whole lot of sense. For instance, I think it might be confusing to a seller when they're signing something that says, you don't have to pay us, basically. You may stop doing business with us at any time. If you accept, then you do pay a fee. If you don't accept, then no fee. I think they're going to maybe get confused as to the listing agreement versus the services being provided as a MARS provider. So it's not really done very well. It's very confusing. What fee do you put in that line when you're disclosing your fee? Is it just a fee that you charge for MARS services? Well, most realtors don't charge a separate fee. It's just part of the services they perform for that seller in the short sale situation. So it's a little confusing at this time, for sure. And like I said, NAR is talking to the FTC. They had hoped to get clarification quite a while ago, but they still have not received that clarification. What NAR is saying at this point is that realtors do not have to comply with this consumer-specific disclosure at this time. Really what they're saying also is that FTC is not enforcing that requirement against realtors at this time. But there isn't anything official yet. And I know I've talked to a lot of brokers who are making the disclosures. They don't feel comfortable not complying, because obviously it complies to our members who are involved in short sale and do these negotiations or discussions with the lender. And so some of them are still making these disclosures at this time, and you definitely can do that. But NAR's feeling right now is the FTC said that they would not be enforcing that disclosure against licensees. The general advertising disclosure, you have to. You definitely have to do. This one you can hold off if you feel comfortable doing that at this time. The other disclosure is when the lender is actually okaying the transaction. So that is, it's provided to the client when the lender's short sale approval letter. And basically what this disclosure, it's in your handout materials too, but basically what it states is, oh, and it's on a separate form too, to let you know it's not stapled. It's on this separate form right here. It's in your handout materials though. Basically what it's saying is this is the offer from your lender. You don't have to accept it. If you reject this, you don't have to pay us. If you accept it, you will have to pay us. And then a line again, so you have to put in that number. It's supposed to be the same number that was in the consumer specific disclosure. If you stop paying your mortgage, you could lose your home and damage your credit rating. So that's the disclosure that would have to be made at the time the lender is approving the short sale. Also, the lender has to provide the differences, the material differences between the current loan and the proposed modification, and whether the seller is liable for any deficiency. So that is the third disclosure. And again, NAR is saying at this time, the FTC is not enforcing that third disclosure against, licensees will not be charged if they do not use that third disclosure at this time. But this is how it stands right now. And like I said, we should be getting additional guidance on this very soon. No upfront fees. If you are a brokerage company that charges upfront fees, if you are providing MARS services, you cannot charge an upfront fee. Use the disclosure in all advertising for short sale sellers. If you are advertising yourself as a short sale specialist or advertising for sellers in a short sale situation, use that, and you have the exact language that you have to use in your advertising. Yes? No, you're not advertising in the MLS. You're not advertising for sellers, and you're not advertising your services as a short sale specialist, because that's when you have to make this advertising disclosure. And as far as I know, you wouldn't be doing that in the MLS, because in the MLS you're just marketing a property. So you would not have to at the time you're marketing a property. You do have to if you're marketing yourself as a short sale specialist, or no. That's when the MARS services requirements apply. But the advertising is when you're advertising for short sale sellers or for yourself as a short sale specialist. And you're not doing that in the MLS, correct? I mean, you wouldn't be advertising yourself. You may have a listing where they are in a short sale situation, but you're not advertising your services as a short sale specialist, and you're not advertising for sellers to list with you that are in that situation. So no, you would not have to do it in the MLS. Only when you're advertising yourself as a short sale specialist, or when you are actually trying to get sellers to list with you. Okay? Okay, so the next thing, you see the question marks there. You may hold off for now on the other disclosures, those other two, the consumer specific and the one that would go when the lender approves the sale. You have to do what you feel comfortable. That's what I tell people with that. We don't have it official. If you want to be safe and cautious, that's me, I would do the disclosures. But NAR is saying at this time, FTC would not enforce or charge you with being in violation of this rule if you don't use those disclosures. And like I said, we should get additional information very shortly. If you are arranging for MARS services, so you're not providing those services, but you're referring them to a company that does, you do have to comply then. Meaning, in your advertising, you have to comply with that part and the other two disclosures, all of them. And watch on our website for updates as we get more information on it. We will definitely update our website. Yes? Flopping? Well, this really has nothing to do with flopping. Because flopping is a situation where, well, I guess you're talking about the situation, it's a short sale situation, but where they turn around and an investor comes in and then basically markets the property before they close on the property, and they close only if they find an ultimate buyer. It has nothing to do with flopping. Yeah, that's a complete... flopping? Yeah. Yeah, and that is a big part of the flopping problem, is the fraud issue, where lenders viewed it as fraudulent because they would see a sale, because the investor would get their offer approved, but they would not realize that the investor is turning around and selling it right away. And they would have a contract then to sell it at a higher price before the investor, before the closing, and the lender knows nothing about it. And so that's what they view it as fraud. And so that's the issue with the flopping, is the disclosure of really what's going on. And it often wasn't disclosed that it was being turned around and sold right away. Yes? I'm sorry, I couldn't hear. What is the requirements for NAR? Oh, what is the requirements from a MARS provider? You mean who is a MARS provider? Who could be? Well, like I said, anybody who negotiates, obtains, or arranges a short sale. Very, very broad definition. You mean as far as having to have a certain license? No. That would be dictated by your state law as to what you do. Does it require a certain license? And some states have very strict regulations as far as people who could talk to the lender in that situation. What you have to watch, the most common situation, or where you could have a problem, is if you're going into what is considered the unauthorized practice of law, to where you're doing legal advice. And that's what we always caution our members in that short sale. When you're talking to a lender or the consumer who is in a short sale situation, you don't want to be providing legal advice at all. So that's our fear here, is you don't want to go too far where it's construed as legal advice. But yeah, if you are negotiating, arranging, that's why you guys could definitely be a MARS provider if you're talking to that lender in that short sale situation. And those foreclosure rescue companies could definitely, that's who really this is supposed to apply to. But anybody negotiating, obtaining, or arranging a short sale. So, okay, I'm going to move on so I don't run out of time.